So good morning, everyone. So I'm saying good morning, but here in France, it's the beginning of the afternoon, actually. But good morning anyway. My name is Florence Gzel. I am a professor of private law at the University of Lorraine in France. I am also an alumni of the Co-Sanders Summer Institute in Law and Economics, which I actually attended twice in 2015 and in 2019, and I can see that I can see some alumni that are connected this morning as well. So I'm very pleased to see them again, even virtually. So it's my great pleasure to welcome you and to introduce and moderate this fourth lecture of the Global Lecture Series organized by the Co-Sanders Institute. So this lecture is part of a series of lectures that are ongoing during the month of September. And the next lecture will be later this week on Thursday with Professor Eric Posner, who will talk about the scope of normative law and economics. But for now, it's my great pleasure to introduce and moderate today's lecture by Professor Omri Ben-Shahar, on a fascinating subject, personalized law. So Professor Ben-Shahar is a professor of law at the University of Chicago. He's also the director of the Co-Sanders Institute for Law and Economics. Professor Ben-Shahar graduated from the Hebrew University in Jerusalem. He earned his PhD in economics and his SJD in law from Harvard. He was an assistant professor of law at the University of Tel Aviv. Then he joined the faculty at the University of Michigan, where he founded and directed the Olin Center for Law and Economics. And in 2008, Professor Ben-Shahar joined the University of Chicago Law School. So as you all know, of course, Professor Ben-Shahar writes in the fields of contract law and consumer protection. He has published many journal articles. He writes a column at Forbes. He is the co-reporter for the American Law Institute's Restatement of Consumer Contracts. He wrote a few years ago a book entitled More Than You Wanted to Know, The Failure of Mandated Disclosure. But Professor Ben-Shahar is also one of the pioneers in the study of the consequences of big data on the law. And he reserves us today the premiere of his new book, co-written with Ariel Porat and devoted to the question of personalized law. And I'm particularly pleased to introduce this conference today because Omri and Ariel have already had the opportunity to present their thoughts at conferences that we co-organized in Paris a few years ago in 2015 and in 2019. And the foundations of Ariel and Omri's reflection were presented to the French public on these different occasions. They built their thinking, they built their thoughts on Casey and Niblet's article that presented their theory about micro-directive. You probably know that micro-directives are personalized legal commands which specifies the exact behavior required in a given situation and then result in a calibrated law. And on the occasion of those conferences, Ariel and Omri questioned this trend. They also questioned, for example, the reasonable person standard in negligence law. For example, they argued that the reasonable person standard could be abandoned and replaced by a personalized level of diligence, what they call the reasonable use standard. So now there is room for a more general reflection on personalized law. And I would say about this that the general idea is that the law could evolve in the same way as medicine. Today, personalized medicine is developing. So the idea is that personalized medicine abandons the paradigm of a diagnosis based on the average person. So personalized medicine places the very particularities of each patient at the center of the treatment protocol. And so the question I would like to ask today is, would it be possible that the law would evolve in the same way as medicine in this respect? And for that reason, and with no further ado, I leave the floor to Omri.
Thank you very much, Florence, for setting up my talk in such a nice way. And thank you for everyone who has joined the talk today. I will put on my slides and you will see me in a small thing. I plan to show my slides for the entire time. So here they are. Norma, if there's any problem, jump in and let me know. Thank you. And thanks again also to Norma Deaxier, who helped organize these meetings we have had. Now we're into the third week of these global lectures, and it's such a delight to see the names of the participants as I look at them. So many people from all over the world that I know and have met and care a lot about. Okay, yes, so in the next 30 to 45 minutes, I will talk about a book manuscript that Ariel Porat and I have just completed. We're just about ready to send it out on personalized law as a phenomenon. I'm going to present some kind of an ideal form. Some will seem like science fiction to many of you. And yet we think that this is a baseline, a benchmark for something that is worth thinking seriously about and trying to understand whether some aspects, some elements of it will be part of our future. The book will be called Different Rules for Different People, Personalized Law in the Era of Big Data. So what is personalized law? What are we talking about? It is something that I want to identify with two characteristics. First, it is individually tailored legal commands. The rules that apply to you would be different than the rules that apply to someone else. They are going to be individually tailored, not one size fits all, but different rules for different people. What does individualization mean here? It means that we look at the internal difference between people, not just the circumstances in which they work, not at the time of the day in which they drove and what speed they should have drove at that time, not in that sense, but who they are. At the same time, in the same weather and road conditions, Ariel will have a different speed limit and rules of traffic than Omri. That is the internal differences that we talk about. So we talk about, for example, personalized standards of care. Also for doctors, different doctors will have to take different levels of care in the practice of medicine under the malpractice standards. Personalized consumer protection. Different consumers will have different protections. Personalized default rules. We'll talk a lot about that today. Personalized disclosures and warnings and food labeling. Different people get different label on the food. Personalized age of capacity. When can you drive? When can you buy alcohol? When can you vote? When can you become president? We now have one rule that is uniform for all, but it could be personalized. So that's the first element of personalized law, and that's the most important one. The second element is more of an implementation idea. How do we know the differences between people? And we think here, and we have derived this notion that it would come from machine-sorted information. Training algorithm to sort through big data about people and identify personal features that are relevant to the goals of the law. So, for example, if in order to buy alcohol, you have to reach an age in which we can trust that you will not behave in a reckless, abusive way, we can find information about you, about the risk that you pose through looking at a lot of data about you. Kind of in similar way and maybe even more advanced than what insurance companies do right now when they try to assess a driver's risk or someone's life expectancy for the purpose of life insurance. Once we have this data, we identify a formula, create a formula. That's what the training algorithm does. And then the screening algorithm just issues personalized commands based on individual attributes. There are a lot of questions of how this will be communicated to people, and we can get to them later on. That's personalized law, and I'm going to spend some time illustrating it in different contexts. But first, the basic question is why? Why change the law? It has always been uniform, the same rules for everybody. Why have different rules for different people? And the reason is really very simple. More precise commands, more precise rules are better suited to advance the goals of the law. For example, look at and Florence has already set it up. Think about what in medicine, if you treat everyone the same, you can give everyone the best average treatment. In education, if you teach everyone the same, you can give them the best average treatment. In marketing, you can find the best advertisement that is sent one size fits all to everyone. But you can do better, both in medicine, education, and marketing, in nutrition, in every area. When you personalize it, you can look at that person and give them the optimal command that suits them. Information to do this was once not available, now it is available, or it's becoming increasingly available. The great American jurist Oliver Wendell Holmes thought about this issue over more than 100 years ago and said that the common law will not do it. The law will not do it, will not take into account, does not take into account the infinite varieties of temperament, intellect, and education, which make the internal character of a given act so different in different men. Why? Because it is impossible to measure a man's powers and limitations. Well, if that's the limit, then as it begins to soften and weaken, as it becomes possible to measure, maybe it's time to reevaluate this basic principle in law, the principle of uniformity. Then there are questions. I told you why personalized law, but maybe we can think about why not personalized law. Is it fair? Is it just? Is it equitable? Is it constitutionally permissible to have differences between the sexes, the genders, people of different religion, maybe race? Is that something we can permit? There are all sorts of other problems that we will touch. Just highlighted them here. We have time to touch on. We have discussions of them in the book, as I mentioned. Okay, so let me jump in and do a quick tour of personalized default rules, of personalized law in different areas of the law to illustrate, to give you a sense of how broad the application of this and how it will change everything we know about the law. So start with default rules. Default rules are the rules that apply unless the parties opt out. Most of the law is default rules. What are the damages for breach of contract? What is the warranty that you get if you buy something? And so on and so forth. They are parties, people can change them. There's enormous commentary in the last decades about how to design optimal default rules. People in law and economics advocated for majoritarian defaults. What the majority give people, what the majority would want to reduce the transaction cost of a purchase. Others suggested penalty defaults. More recently, inspired by nudge, scholars have thought about enacting sticky defaults, make them sticky so that they will be hard to change in order to advance social goals. Notice, though, that whatever your theory of default rule is, it is always uniform. They do not vary across people. There's some crude contextualizations, consumer versus business people, one shot versus repeat, and so on, but it is not, does not vary consumer by consumer. And that seems, default rules are suited for personalization. It is something that is easier to digest because the goals of default is to mimic people's preferences, to give them what they want. And people already sometimes contract around the default, so we have data. What do they choose? They don't, personalized default don't really raise problems of equal protection. Different people having different defaults means everyone gets something better than what they currently get. And so what if it's different? If different people can choose different ice cream flavors, do we say that we have problem of equal protection? And Sunstein, in a prophetic article 7 years ago, imagined something like that and said it is a good thing to do, to personalize the default rules when people are heterogeneous, when we have information about it, and when for them people to choose their own rule is costly. Thereafter, Porat, my co-author, and Strahilovic wrote a fantastic article looking more deeply into that idea. And one of the examples that they gave is the personalized inheritance law, what we call the intestate succession rule. What happens if someone dies, leaves an estate behind without a will? How is it divided? Well, it is presently divided in the same way for everyone. In Illinois, here in Chicago, 50% to the spouse and 50% divided among the children. But there is data already that shows that different people have different preferences. Men want to divide differently from women, wealthy different from less affluent people, people who have were married more than once have different preferences, and so on. So I mentioned that we can have for different people different inheritance rules, and we can have data about what people want because we can look at wills that have been written and try to find patterns. What do different people want? And so another example is organ donation default. What happens if you die? Should your organs be donated? People have different preferences. Why should we have the same default rule for everyone? Pension plans. How much would you contribute to your pension? Again, there's a lot of commentary about it. Should there be an auto-enrollment or just let people choose? But whatever it is, currently it is uniform. We can fit people with different defaults based on what we know is they usually do or should do. And similarly in consumer contracts. Think about privacy rule. Big issue recently. A lot of fight and changes over what is the privacy rule, but these are default rules. People can change it, can agree to give more data about themselves than is currently allowed to take. It's a default, and therefore it could be done differently for different people based on their preferences. That's one example for default rules. Now I'm moving, and I put on a slide, I hope you see it, personalized mandated disclosures. So mandated disclosures is something that I've written and maybe spoke to many people here in the group before. These are laws that require to give people information and warnings to help them make better decisions. And I was never a big fan of mandated disclosures. And so I'm asking now, could personalization rescue this very common, maybe the most common, and in my view, the least successful regulatory technique in consumer protection, in all of law? Can we do better? This is what, and you've seen me, maybe some of you saw me post this picture. This is what impersonal disclosure looks like when the fine terms of a contract are shown to you. And so I just once printed them out and hung them from the ceiling. It is not a very helpful legal intervention to give people these kind of disclosures, whether in digital or paper form. But when it is personalized, you will only get the tiny little snippet that is relevant to you. When you see a label on a drug or on food or on a product, you won't have to see all the information, only the information that the algorithm predicts you will be interested in. You might see scores and ratings, but not the full disclosure. We want to replicate the success of personalized ads. Ads are also a type of disclosure, and they are short and they are effective. Why can't the legally mandated information do it in the same way, and they can do it perhaps in the personalized fashion? There are reasons to be hopeful because it will less overload just-in-time information that takes into account your specific and personal cognitive limitations. And it will tell people what the algorithm predicts will happen to them so that they can take it into account. That seems to be something that people will pay attention more than the current all-inclusive uniform disclosures. There are also reasons to be skeptical because sometimes many times the decisions people have to make are complex and cannot be simplified effectively. For example, how do you simplify a mortgage disclosure? This was my mortgage disclosure. 50 different forms were given to me when I signed my mortgage. How do you exactly personalize that? Personalize each one of the 50? It's not good. There are reasons to be skeptical, and there is some discouraging evidence. There's already someone who tried to show in Mexico, they did the credit card disclosures that showed people where they are on the risk. In the US, we have personalized credit card disclosure telling you how much you will have to pay if you only pay the minimum. Those have not been successful. Those have been complete and utter failure. So I'm proposing that we think about personalized disclosure, but only to the extent that we will have evidence that they work. It's an idea, it's not, I'm not super hopeful. Separately, let's move on in our tour of law, all of law. Let's move away from the default rules and disclosures and talk about negligence law, tort law. Should standards of care be tailored to the characteristics of the specific actor? The existing law says no. We have this notion of the uniform person, the reasonable person, and it's uniform. Based on averages or norms in the society, every doctor should abide by the state of the art in the profession. It's the same. There's some limited tailoring. Maybe experts have higher standards, but all experts have the same higher standard, not personalized higher standard. Personalized law will transform the reasonable person standard to the reasonable you. What you can do best given your characteristics. There will be higher standards of care for people that are riskier. If they have bad impulses or poor eyesight or love risk, well, you better take more care. The standard that the law will hold you to, or else you'll be liable, is higher. There's also going to be a higher standard for people who are more skilled at taking care. And if they have better training, more experience, we can demand more from them because it's not as expensive and crushing for them to take more care. Ariel and I wrote our first article on this topic in this issue, and we examined it. So let me just give you very briefly some flavor of the value of personalized negligence law, that personalized tort law. Care will be more efficient. There will be less accidents. Instead of 40,000 fatalities per year in car accidents in the US and endless numbers of medical accidents, there will be less because the level of care will be fitted more to what people can really actually do. Dangerous actors will take more care. The second claim we make is what will happen to their victims? Victims can also take care, and can take contributory care. And it might be harder for them if the potential injurers are behaving in a more volatile way, not the same way. Think about a pedestrian wanting to cross the road. Cars are approaching. In a uniform law world, all the cars have to drive according to the same speed limit. So the pedestrian sees relatively uniform and predictable movement and can predict and can anticipate the risks and cross the road safely. In personalized law world, different cars will be driving according to different speed limits. Speed limit is a form of precaution. So good drivers, more skilled, less risky, can drive faster. Now our pedestrian will see the cars approaching at different speeds. So we might worry that it will be harder for people to anticipate the risk environment, and that could be a downside. But my response is, actually, it's exactly the opposite. The risks created by the different drivers, the different injurers, are actually going to be less differentiated. In our present uniform world, people drive the same speed, but they are not all as good drivers. Some are creating higher risk and some are lower risk. what really matters to the pedestrian is not the speed, but the risk. Uniform and personalized law can have a world in which everybody creates the same risk. Even though their standards are different, they are calibrated so that the risk will be more uniform. There is another claim, another problem with personalized law, and that is that if we increase the duties of care to people who have more skill in taking care, that will undermine their incentive, their motivation to improve their own skill. For example, if you train in a new technology, you learn how to do something, now the law will require you to take more care or else you'll be liable. This is a general problem with personalized law. Every time the legal treatment results from self-improvement is more demanding, every time if you become more informed, the law requires to give you less information. It changes your rights and duties. In those situations, there will be distortion in this self-improvement incentives, in what you invest in your own capital. And the response is, well, that's true, that's a problem. What we can do, therefore, is for personalized law to rely on personal features that people cannot manipulate, like inherent traits. What's your age? How many years of experience you have in something? Or a proxy. I recently received a letter from I recently received a letter from my insurance company asking me to send them the grades of my 18-year-old son in high school in order to qualify for a discount. Why are grades related to discount? Well, there is a correlation. We can all participate. The insurance companies found a correlation. Students with high grades cause less accidents, but that's a proxy for something. It's not really, that's what I call a proxy, and that is less manipulable. Okay. Finally, in my survey, I'll talk about personalized consumer protections. Consumer protections are mandatory rules that parties cannot change. They kind of govern consumer contracts and say, you must give people, you sellers must give buyers at least these basic rights. We have many examples for consumer protection. There are the rights to withdraw is maybe the most important type of consumer protection that has been added in recent decades in many countries. Privacy protection is increasingly mandatory. Some warranties, like lemon laws, are mandatory, and damages for dangerous products. The optimal protection, why are we giving consumer protections? Why can't we say to people, oh, just contract for it? We think that there are weaker populations who are not going to be able to secure these rights, and they should be receiving it, even if they are not contracting for these things. That's the basic level of dignity in our society. But not everyone is weak. What counts as a weak consumer, it's just a label we put on different attributes that have to do with wealth and income, education, health, age, cognitive problems. These are things by which people really vary. Our present system gives the same protection to consumers who really need it, who are at the far end of the weak population scale, and to millionaires. And in fact, we know that sometimes it is the stronger groups that enjoy these protections more. What a scam. So let's change that. Let's have protections that go to the person, not to everyone. They would be treated given based on specific need that is predicted by the screening algorithm. Now, mandatory protections generally raise prices. If sellers must give some warranty, if they are subject to some limitation, they charge something more for it. And so they could be given selectively places where the value that they create for those weak populations are greater than the cost that they would be added. That's the difference between optimal protection and personal protection. We look at the personal value, not the average value, and the personalized cost, consumer-specific cost, not the average cost. This will increase consumer surplus, especially to those who really need it. Prices will adjust, but people will make more efficient purchase decisions. The protections will be given only to those needing them. And if the prices will be personalized to reflect the different protections, ultimately there will be less cross-subsidy. And my belief is that in many contexts, and I've shown data on that, less of the cross-subsidy is currently going in the wrong direction. Poorer people are subsidizing the protections that more affluent people enjoy. That should be changed. Okay, we looked at default rules, disclosures, personalized negligence law, personalized mandatory law. What's left? Let me just give you one slide of additional illustrations of what personalized law could look like. Personalized age of capacity. Some people can buy alcohol at the age of 18, some at 21, others at different ages in between, depending on how what we know about them and what we can predict they will do, especially the risk of drunken driving. The same for, let's say, driving. Personalized property rights. That's a topic that we discuss in the book. It's a little more technical. I'm not going to get into this, but it would spell, personalized law would spell the end of numerous clauses. The fact that property rights are uniform and you always get the same bundle. Personalized criminal sanctions. Personalized sentencing is actually something that is already being practiced in the EU, have always been, but is increasingly being practiced with the aid of algorithms, very controversial, but also offers many interesting ways in which, important ways in which to create less disparity, especially less racial disparity in sentencing. It is one of the biggest problems in American criminal law, in American social justice in general. The racial disparity in criminal law, and personalized law will actually allow us to measure, correct the current distortion. Personalized damages and compensation. And think about a completely crazy idea, personalized constitutional rights. Some people will have more protection, First Amendment protection for speech, others more protection for property rights or for against illegal searches. We float this possibility in the book. I don't like it. Constitutional rights are not meant to serve the individual. They're meant to create some kind of an ecology in which we live. Economists will call it externalities. They affect everyone. And so it's not a good area to think about personalization. I raised it here to give you a taste of maybe what would be the limits of personalized law. Briefly, let me suggest run over a few objections. I would like to have the audience raise some of them, but there are questions. These objections are all dealt with in, I think, in some depth in the book manuscript. Distributive justice and equality are the main issues that we have to worry about. Equal protection, problems of coordination, and problems of manipulation. Let me say a few words about this, especially about the issue of equality. Is it just to give people different rights and different duties? Equality under the law is the most basic idea. You know, Florence is with us. The French Revolution has bestowed upon us the égalité as the pillar of what a just society is about. We're taking away equality with personalized law, are we? Well, think about it actually. Uniform laws, uniform allocations are often unjust. They fail to take into account relevant criteria of who needs more and who deserves more. We can do better. I'm reminded, I'm translating from the famous, the great French thinker Anatole France's statement that the law in its majestic equality forbids the rich as well as the poor to sleep under bridges, beg in the streets, and steal bread. Maybe we need to have different rules for people in order to promote equality. Equal access does not mean equal distribution. That's the point. And uniform laws are currently applied via judicial and enforcers' discretion, often resulting in implicit bias and indiscrimination. More to the point, equality does not depend on how many factors are used to differentiate the people, but how relevant they are. If we can use more relevant factors, we are advancing the principle of distributive justice. Think about alcohol age rules. They're already treating people unequally. Right now, we have a uniform rule of 21, age is 21. So we differentiate. We tell people under 21, we treat you differently. That's unequal, but we think it's justified because it's a relevant criterion. Instead, we can use more relevant criteria, not just age. That would promote the equal protection. That's the same way that insurance companies charge more premiums to high-risk people. It's called actuarial fairness. I'll just mention that in the personalized law, you can impose on an algorithm a constraint, a command, to take one individual feature, for example, race or sex or other things that we really care about, and say, along this line, along this particular criterion, everybody has to be treated equally. You can differentiate between them differently, but we want average men, women treatment to be the same. There is a problem of data because we're going to rely on data that has been based on historical biases and injustice. But that's a major problem for any kind of use of algorithm today to promote kind of predictions and treatments. But unfortunately, it's not just a problem of algorithms, it's a problem of judges as well. They're prone to historical influences. It actually is easier to identify disparities when algorithms are used, and it's easier to fix them statistically. Lastly, there is the problem of equal protection constitutional law. And I will just briefly say that there is a big question here. Could personalized law, would it use suspect classifications like race, like sex, like religion, gender affecting the age of legal capacity, race affecting organ donation default, because the surveys do show that there is a racial difference in the preference of people, ethnic and religious affiliations affecting disclosures and mandates, age affecting standards of care, and so on. These are all suspect issues, sensitive issues that we usually, there are anti-discrimination laws tell us not to use these factors. The thing is that people are not going to be treated just by being men or women. They're not treated, they are treated individually, not by a class. Membership in a class, gender, sex class, racial or ethnic class, might have only a marginal impact. And as at least according to American Supreme Court, my claim in the book is that that is permitted. In conclusion, I want to say something, and maybe if I can, I will show you a very short clip, and then we can move on to the question. In a very memorable, many of you may remember the movie Monty Python's Life of Brian. In a very memorable scene, I want to show you a memorable scene and tell you, then we talk about what we just seen. So let me briefly stop sharing my slides and share instead the YouTube clip here, very short, a few seconds. Can you see it, Florence?
Yes, I can.
Okay, here, this is a clip from the movie Life of Brian. You're going to see the prophet, someone who the people believe to be the prophet, Brian, and how they worship him. So pay attention.
please listen. I've got one or two things to say. Look, you've got it all wrong. You don't need to follow me. You don't need to follow anybody. You've got to think yourself. You're all individuals. Yes, we're all individuals. You're all different. Yes, we're all different. I'm not.
So what did we just see? What did we just see in Brian, this satirical Brian, who is mistakenly thought to be the prophet, tells the crowd to stop worshiping him as the Messiah. You're all individuals. Yes, we are all individuals. He begs the mob, and then you're all different. We are all different, except for this one bashful fellow standing there among the crowd who says humbly, I'm not. So uniform law, I'm saying, has been with us for millennia. It is easy to administer. It provides the safety of herds. But maybe the availability of big data and artificial intelligence and the emergence of personalized schemes in other sectors would inspire us to develop a regime suitable for those who want to say, I'm not. Thank you.
Okay, thank you so much, Amaury, for such a fascinating and inspiring presentation, an inspiring conclusion. So I could see that, you know, there are already reactions among the audience. So I had prepared a few questions, but I suppose I should leave the floor to a few people who have already raised their hands. So there is a profile that is called COS 2020. So I don't know who is behind this, this name, but please go ahead.
Hello, thank you. I would like to ask if this personalized law could be implemented, when and where would it be implemented? Because that's a big question, since I don't really see China doing that. And in Europe, there's a problem, since the Western Europe and the Eastern Europe are just so completely different. And also the American context is quite complicated too. And the second question would be, if we could use data to personalize rights, basically, and of course punishments, because it's inevitable. Who would watch over the guardians? Because when you have so much data and so much control, and you would basically say you can do that and you can do this, but who will be the one that would watch over the ones who would watch you? Thank you.
Yes, a wonderful and difficult question. Where would it be used? So it could be used. How to apply it, to implement it, is a political question. My contribution is to provide a framework to think about it and to show how far it can be stretched and what are the issues that come up for good and for bad. We would definitely want to implement it in areas where we have the data, where it does not raise issues of equal protection, where it does not lead to manipulation of the data, of the behavior by people. And that's why the first idea on personalization law came in the context of default rules, how to personalize default rules. And this is something that would raise less objections and be easier to do. And so I see that as the place where if you needed to do something tomorrow morning, that's where you would start. But the big value would come in areas like negligence law and consumer protection. And whether we have the will, the political will to do this in an organized way, rather than to leave it for judges to occasionally personalize the treatment through litigation, is a fascinating question. I'm not sure what it is. I can totally imagine, in the spirit of the question, that we will not implement this, that this will remain as science fiction. Whether now the question is do we trust governments with this kind of data? No, and therefore we need any kind of big data enterprise has to have a lot of safeguards. The kind of safeguards that are already being invented and implemented in the context of commercial big data would be have to be multiplied when it is governmental big data. Nevertheless, we begin to see implementation of personalized treatment in the context of criminal procedure, sentencing, risk assessment, risk predictions, granting of bail, and so on, parole. And it is very promising because you can see exactly how people are treated. It is no longer a mystery whether there is abuse or disparity in that part. And it's also very easy to fix. It is as easy as a line in the code to tell the algorithm, you must make sure that people of different races are treated the same. That's all it takes. Imagine how hard it would be to do if we were to use judges and try to instruct them to do that. So there are flickers of hope.
Okay, so thank you very much, Omri. So the next in line is Yu-Chen Chiang. Hello.
Hi.
Hi.
Hi, Omri. Thank you for the great talk. I'm so excited to learn of the new book manuscript. I have two questions. First, you said that algorithm could be instructed to do certain things and the pattern could be easily discernible. But to really personalize, at least the current technology requires us to do deep learning. But deep learning is a black box. No one knows how they find the pattern. We just know that they find pattern that is highly predictable. So we really cannot put them to task for the algorithm. And it's very hard for human beings to read through, for example, AlphaGo's deep learning algorithm, because each move involves a million lines of computations. And I don't think it's easy to really put them to task. Second question, in your original paper with Ariel in NYU Law Review, you talk about the opposite pulling force of risk versus skills. Sometimes high skilled people have low risk, high risk people have low skill, but they each require more like higher standard of care. I wonder whether in your book manuscript you have find a better way to deal with this opposite pull, because I have cited your work in my own discussion of good faith purchase rule. And again, there, if we want to put more burden on professional sellers, the high skilled persons who are low risk, or whether we want to put more burden on the one-shot seller who are high risk and low skill. And eventually I go with your suggestion in the paper in choosing risk over skill. But I would appreciate if you could tell us more about your new thoughts. Thanks.
Well, thank you. I will speak briefly first to the second question. When Ariel and I started thinking about it, we did not think about the whole big data aspect of personalized law. And we said, let's look at our just the personalization issue. Whether different people could be faced with different personalized standards of care. And we thought about that people differ. In what ways do they differ? They differ in the risk that they create, and they differ in their skill of taking care of, as you mentioned. That is something that we are now thinking about differently. Risk and skill are just shorthands to each one stands for a whole array of issues. Your bodily capabilities or your mental capabilities are both affect your riskiness and affect your skillfulness. What we really want to measure are those things, and how, as you said, the deep learning will identify which aspects are more relevant to the creation of higher accident risk. So I guess we've moved to some extent away from this duality of riskiness versus skillfulness, and towards the more kind of big data thought of it, a multi-factor. Yes, the algorithm will identify features, you're right, and that we will not fully understand why. But we will know from the output. We're not sure how the computations were made, but we will know from the output what are the features that are being used. And we can put it to test and see, whether we get improvements once we begin to implement a particular a personalized law. That would be some kind of an experimental pilot programs. For example, we can do that more easily with default rules where the stakes are smaller. The fact that people will not understand, people in general will not understand why they are being treated this way or that way, I don't think that is any different from the present law. When someone is told that this is the standard of care that you are owed, they can ask why, but we won't be able to give them good answer. Well, based on the distribution of in the population, this is what we think a normal person should do, an average person should do. Why? Well, it's hard to tell you why. We kind of did it roughly so. It's intuitive. Intuition is much harder to probe. The deep learning that undergoes there is much more mysterious than whatever algorithms will do. So hopefully we will ultimately simplify the transparency of how legal standards are being set.
Okay, so we now have a question from Joasia Luzak.
Thank you, Eleni, for your interesting presentation. Can't wait to read the book. As you know, as a consumer protection lawyer, I'm mostly interested in personalized default and personalized mandated disclosures. And there I was wondering, because I would very much like to see this happen actually, and move away from this one-size-fits-all approach, see whether personalized mandated disclosures, for example, can help us save this consumer protection instrument. But I was thinking then about solutions, and the solutions also you mentioned, and I wonder whether, for example, the fact that with personalized defaults, you can say that, well, with any defaults, whether they are personalized or not, there's an option to move away from them. With personalized mandated disclosure, you could say that you will show the most relevant for a given consumer information, but you will leave the other information available, so accessible, hiding behind a hyperlink or something. And I wonder whether that could be seen as enough of a solution, especially if it could be said based on behavioral data that consumers do not change their defaults, that even if you make the additional information available, they won't, we know it, access it, or it's unlikely they will access it. And the second question that comes with it is the issue of evidence, especially with personalized mandated disclosures. If certain information only will be revealed to consumers, are traders then supposed to collect all the information that they reveal to all individual consumers to be able to then prove that they haven't manipulated this information, that the information was not misleading, for example? I think that could cause quite a lot of practical issues for, and quite a lot of costs for traders.
Mm-hmm. It's not very nice to see you, Joasia, and thanks for these really great questions. Definitely, you've thought about some of these issues, and apparently deeper than I have. And so it would be wonderful to talk more about this stuff with you. I'll talk about manipulation by disclosures in a minute. But your first question maybe allows me to suggest one thing that I can further clarify about the scheme in general. And that is that it is possible to do personalization of any legal rule, and especially of default rules, only to those who want it. Namely, create personalized law. Some people will get it and some people not. You allow some people to predict that they don't like it, and they want to live by some kind of one-size-fits-all, or let people opt out of personalization. This kind of or do personalization only one-sided, only to raise standards of care, not to lower them, things like that. There is room to play with this kind of device, to use it as a dimmer. And I think your first question at least implies, give me the opportunity to suggest this possibility that some people will be fitted with a different regime altogether, more towards the uniformity. As to manipulation, by the way, the topic of manipulation is something that I'm currently super interested in, and I've been writing a couple of papers with Oren Bargil, trying to understand what's going on, how consumers are being manipulated without being lied to. And one of the ways in which people are being manipulated is by when sellers and businesses are giving them information that they don't need. They show some feature of a product that people think is great, but that allows them not to make salient other features of the product that really make it terrible. That's our experience all the time, that we are being manipulated by being given partial information. We are also being warned in a manipulative way. They don't always warn us about the most important things. So manipulation is a problem in a regime in which the law tells sellers, disclose everything. Consumers have the right, the autonomy to know everything. So they disclose everything, and they hide in page 17 the really important things that we need to know, don't need to worry about. Well, personalized law will say, okay, you don't have to disclose everything. Disclose just that thing on page 17. Everything else is less important for this consumer. I kind of think intuitively that that would lead to less manipulation. Should we move on to?
Yes, if it's okay with you. Yes, we have a question now from Ken Chu.
Hi, thank you, Professor Ben-Shahar, for this interesting lecture. My question relates to when should we use personalized consumer protection law to interfere with the market? I find that without intervention from consumer law, some private firms are already offering personalized warranties for consumers with different preferences. For example, for $700, you can buy an iPhone 11 with standard warranties. For $800, you can get the same iPhone together with a set of additional warranties, including better repair services. Although such personalization is done not because of consumer protection concerns, iPhone sales contracts may be still a step closer to the ideal status where consumers can have the levels of protection that match their needs, increasing social welfare. So I'm wondering how we can decide whether to implement mandatory law to offer personalized protection when the market can somehow provide similar protection to those who value them. My initial thoughts would be if consumers normally do not suffer from irrationality when doing the activity, like when entering into simple sales contracts, we can leave it to the market to offer personalized protection and no need to implement mandatory law. So I would be very happy to know Professor's thoughts on this.
Yes, thank you, Ken, and it's nice to hear your voice again. Markets provide everything that we allow them to provide. And you're right that so much of the experience is increasingly personalized, including the legal terms, like the type of warranties that people get. The markets offer them and people select from a menu. When people walk into a restaurant, everything is personalized. You get a menu and you choose. When I talk about consumer protections, I'm referring to the things that people cannot choose. The minimum quality or the minimum safety that the law imposes, both on the quality, on the actual construction of the product, but also the legal terms. What kind of legal rights people would have at minimum. And here, we don't have any personalization because the market is not allowed to take away. To make things lower, it can make things higher than the minimum, the basis that it is required. And I'm saying, well, maybe even that basic threshold, that minimum threshold, should vary between different people. And we should make sure that we give that protection to those people who really need them and don't abuse them. And we use in the book the example of the right to return products, the right to withdraw, a very important mandatory protection that required by law. It's true, businesses, stores sometimes give even longer right to withdraw. But at the very least, you need maybe 2 weeks or 1 week or 72 hours, depending on the transaction. We know that some people abuse this. They are habitual withdrawers, returners. Even stores and businesses in the US have become to collect data about this returnaholics who just buy in order to return. Buy a nice fashionable dress, wear it once and return it. Buy a big screen TV for a party and return it. This is abuse. And because of this abuse, everybody pays higher prices. So maybe some people should get more of the right and some people should get less of the right. Ultimately, the goal of mandated protections will be better served.
Yeah, sorry, can I have a follow-up?
Sure.
So I understand that maybe for more sophisticated products, like some financial products, like private investment funds, there are some jurisdiction may have a mandatory rule for a cooling off period. Like for sophisticated investor, the cooling off period may be just 24 hours, but for like some individual investor, maybe the cooling off period could be longer. I guess that's what you are referring to for mandatory protection. So I see from this example and the iPhone's example, maybe the difference should be that the iPhone example, in the iPhone example, I think maybe the consumers are not that kind of biased, or they are not easily to be trapped by the contracts. But when there are lots of traps or people can have lots of bias, then that's more need to have a mandatory consumer protection law. Is that true?
Exactly. The features that we want to first ask ourselves, what are the goals of that particular protective regime? And to identify what are the issues that make people vulnerable. What do we mean when we say vulnerable? In different markets and different products, it's a different problem. Sometimes, and once we identify what is the core problem, we will ask, who are the people that have this problem? Let's try to predict whether you fall in and out and to what extent you're in this set of vulnerable population, and provide you, and only you, if you're a member of that set, with the protection.
Okay, so now I'm reading a question from Jose Eduardo Martins. So I'm just quoting. How can I prove that I had a change of attitude, able to change the personalized law? For example, I no longer follow a life of criminal activity. How to remove the most intense restrictions of the personalized law?
Wow, that's a really good question. One of the features that it allows us to discuss briefly is the fact that however we characterize people for the purpose of legal treatment, it should be a dynamic criterion. As it changes and as we have new information, we will change the treatment. And someone who was once classified as dangerous could gradually shift to less dangerous for the purpose of various treatments. Now, it is true that criminal record would count in predicting people's behavior in the future, because we will likely see in the training algorithms that it is correlated with behavior that could be dangerous in the future, but not for everyone. So the question is, what if someone wants to change? This problem is not unique to personalized law. Uniform law currently takes into account criminal record in a way that is very hard to change. Once it's there, it is taken into account. The thing about personalized law is that no single feature will have a dominant impact. The fact that you have a record is one of 100 other features that predict your dangerousness. We can look at Facebook behavior. What do you say and do in Facebook? And what kind, we can look at driving records. We can look at your bank credit card records to figure out what kind of risk-taking behavior you take. And if you would qualify, you've changed your style of life to be less risk-taker or less dangerous in some other respects, the data will capture it from other aspects. And the fact that you're still saddled with the record of past criminality will not have such a dominant impact in how the law will treat you forward-looking.
Okay, thank you so much. So the next question is from Gustavo Rodriguez.
Hi, Henri. Really nice to see
Gustavo.
you. Thank you for that amazing presentation. So you mentioned constitutional law as a possible limit to personalized law. But in a way, constitutional rights are applied differently. I mean, the exercise of a right depends on personal income, and that's always different. So I was wondering if you could say maybe a few more words regarding this issue. Thank you.
You're raising a pragmatic issue. You're absolutely right that people have in our regime of equal constitutional rights to all, not everybody can exercise their constitutional rights with the same vigor, in part because it takes, we need to know how to do it and how to fight for it. And the reality of American constitutional law is of a lot of discrimination. Even the discrimination that is prohibited, that is not allowed by constitutional law, we still have measure and see that Black defendants get longer sentences, that women receive lower compensation awards for when they are discharged from employment illegally. All of these things violate constitutional rights, and yet they exist under uniform law. The nice thing about personalized law, if we were to apply it to the statutory rights, the nice thing about personalized law when we apply it to statutory rights is that we can see disparities and see if they violate our constitutional requirements. Separately, if we tried, and I mentioned it, to apply personalized law to constitutional rights, to say that one person would have more free speech rights than others, now you're telling me, well, that's what's going on anyway. Some people are better at securing constitutional rights. Well, I say that's terrible. They shouldn't be. The whole point of many of these constitutional rights is to create an environment, not give people something for their own private consumption. And so we need to try to limit that. And if it's occurring under our present regime, it's not good. And I would not necessarily advocate heightening disparities in constitutional rights through personalized law.
Thank you.
Okay, so now we have a question from Zichao Yang.
I think it's me.
Well, you were the following question, but just go ahead. Yes. Okay.
Okay. Just two very brief questions. One is concerning transparency. How can we know ex ante what law we are following? Second one is concerning equality. Say more experienced consumer probably will have advantage from personalized law, so they can choose a high quality default rule. In that sense, the less experienced consumer may have to take the low quality default rule. So that's my second question.
Great. So, the fact that people with greater experience and sophistication already are able under uniform law to get better legal treatments and to choose better provisions and override default rules. I am not sure that under personalized law, that advantage will remain. because those people who are bad at choosing, they have different preferences from the default rules. They would want something different, but they are not good at choosing it. Will be given it automatically. They will be automatically enrolled into that treatment that based on past experience and analysis of their preferences predicts what they want. As to the question of how will people know, that's a difficult question. It's a good one, and I'm wrestling with that. We've been wrestling with that in the book. We have several thoughts about it. First, things can be communicated in the context of personalized speed limits. When you drive, maybe you'll be connected and it will be flashed in your car. But in other contexts, there will need to be some kind of more connection. If you want to know what is your personalized default rule for the purpose of inheritance law, how do you know it? Well, nowadays, you have to get legal advice or open law books. Most people don't know. We think that it would be, part of the fact that this is all now planned by an algorithm. Just give people access to inheritance.gov. You log in, you put in your social security number, and you see your allocation rule. If you want to know whether you are enrolled as an organ donor by default, look, there will be a website. You do organdonor.gov and see what's your default rule, and then click if you want to change it. And this kind of, once we allow artificial intelligence to create the rules, it is also, we can maybe try to build platforms in which people will be able to interact and know what they are. Finally, with respect to standards of care, to know what is the standard of care that you're held to, what is reasonable behavior. Today, we tell people, you should think about what the reasonable person is. Do you know what the reasonable person is? Do you know in every area what is the requirement? I think that it might be easier to look into yourself and ask, what is reasonable for me? I know myself. I know my strengths and limits. I know that the law now knows them too. What is it that I should be doing in order to act reasonably? Maybe it's easier to know.
Okay, thanks.
Okay, so now there is a question from Zichao Yang. So the floor is
Hello?
yours.
Hello, can you hear me?
Yeah.
Yes.
Yeah, we do.
So my question is there any empirical research that shows people have different demands in their legal rights? I mean, if the distribution of the type of demand of people is normal distribution, then in this kind of situation, the implement of the personalization of legal system will be very costly in the sense of cost-benefit analysis, because it only satisfies the long-tail demands. That's my question.
The basic premise of this project is that people are different in ways that are relevant to their legal treatment. I think it's hard to doubt the validity of this. I don't know that I have in every different area empirical data about how different, in what ways they're different, but it's hard for me to imagine that we think of people as we said, we are all individuals, but we're all the same. The whole notion of a more liberal, the ethos of liberalism is that people are different and they should be treated differently in the ways in which they are, where their differences are relevant. How differently depends, and how proportionately are they different? These are things that are, of course, differ from area to area. To resolve the empirical question, in what ways that are relevant are people different, we need to find devices that will be fed with data. And that's why part of the proposal in this book is to use big data and survey and large surveys and whatever it is that is available to try to analyze the relevant differences. But that is, I totally recognize that this is a project that we've not run a pilot of how to do that. We're just offering a thought experiment how that could be done. Maybe we'll take one more question, Florence.
Yes, we have a last question from Filippo Lancieri.
Hi, Omri. Thank you for the excellent presentation as always. I wanted to ask a bit of the flip side. So what do you see happening to governmental responsibility in this new world? Because governments are going to get way more power and there's definitely going to be a lot of mistakes. Do you see more room for people suing the government for wrong classification and then getting damages or something like this? Or do you expect things to remain the same?
Thanks, Filippo. It's really nice to see you. Thanks for joining us. Governments will have a lot of power, differently than they have now. The decisions to issue legal commands will not change, but they'll have more data. Whether that translates to more tyranny or less, I'm not sure. Because when you have the data and when the data has to be exposed and used in a transparent way, that might give the government ultimately less power. So, when judges are making a multitude of atomistic decisions, we don't really know when they make mistakes. With the algorithm, we will know. And there might be an illusion that we're making more mistakes because when an algorithm made a mistake, it is multiplied for everyone that was treated. Whereas when a judge made a mistake, it was one time. But many judges make mistakes. So we don't know where the total sum of mistakes will be greater. But we do know, and I think this in reading the literature, the use of algorithms to create treatments in many other contexts, is that we can identify the mistakes with algorithms, something that is very hard with judges. And we know that we can measure it. And again, another thing that is very hard with humans. And finally, we know or hope that we know how to fix it. Another thing that is direly hard with humans. And so the government will have all this power, but it will be done through a channel that in the best case scenario will be subject to a lot of discipline that will allow us to make sure that the terrible things do not happen.
Okay, so thank you very much. I think we don't have any more questions, so we can end the session. So thank you very much to everyone for joining us, and thank you so much, Omri, for so many questions and ideas. See you very soon, hopefully, for the next lecture with Eric Posner.
Thank you. Bye-bye.